Here's what I'm going to do. I'm going to go to a little bit of a faster clip now. I want to drop into some very specific areas in the film timeline. So I'm going to hold the questions until the end because my goal is to try and leave ample time for Q&A and some very targeted answers for you guys. So I want to get through a couple of things and do it very quickly, and I will try to keep down the amount of detail I go into about the law and just kind of give you guys what you need to know to work from here. That being said, I do need to spend 1 minute on two areas of contracts that are going to come up again and again and again, because when I talk about the other contracts that you need for this next 45 minutes or so, these will come up time and time again. And they're not things that are always intuitive. The first is the concept of defined terms. A defined term in a contract means that whatever we say this term means in the contract, that's what it means. Don't look at the dictionary. So if I say your copyright is defined as the word horse, every time I use the word horse, you got to think it's the term copyright. So here's why it's important. Lawyers will sometimes play tricks. Maybe not intentionally, maybe because we're just trying to do things simply and we do it in a way that's counterintuitive. But if I define in the contract with you, motion picture shall mean the motion picture currently entitled Zombie Sharks in Love, and any other motion pictures, remakes, sequels, television motion pictures, or other derivative works based on that. Now, you may be reading this going, motion picture, it's just the film we're doing. No! I've now swallowed up your rights to toys and to derivative works. So be very careful of those defined terms. The devil is very much in the detail, and that's the part that it's so easy to go, motion picture, I don't know what a motion picture is. That's the one thing I do understand in this contract. I know what a motion picture, no, that's where we get you. The other thing, and I'm glad to see that Anthony and I were taking a look at it. He was very generous yesterday in showing me some of the contracts that you guys have here. And there's a similar concept. Representations and warranties. Representations and warranties are in the contract promises that each side is making that are accurate and true. So a representation warranty I might make is that I own the copyright that I'm granting you, or that it won't infringe anybody's rights anywhere, it won't be obscene anywhere else. And in my experience, this is the part that clients are like, yeah, whatever, legalese, boilerplate, I'm just going to go past this. But coupled with those promises is something called indemnification, which means that if you have made misrepresentations as to any one of those statements, and those misrepresentations cause a party to the contract to be sued, you have to pay their legal bills, their damages. But it gets worse, because anybody who down the line, let's say you do a deal with a production company and then they bring it to a distributor, and that distributor will get sued if it's copyright infringement, everybody down the line will be able to look back and hit you up for the legal costs, and that's called indemnification. So you have to be very aware of what you're doing here, and with this idea of copyright, you have to be able to say, yeah, I own the copyright, and know that. And there are some other areas too, like defamation law or obscenity law, where you might understand that your film doesn't violate those laws in your country, but I can guarantee you that a simple kissing scene may violate the obscenity laws of some countries in the Middle East. So there are ways around this, but you have to know the importance of what you are promising. So I know a very cursory overview of that, but I want to sort of put that front and center. I'm going to jump to a couple of things in development now. When we're in the development section of the filmmaking process, we're concerned with getting the rights, we're concerned with raising the money. I want to talk about one of those things in particular that we've spoke a little bit about, and that is protecting ideas. Now, as Anthony said before, you can't do it with copyright under either Trinidadian or under US law. The best way to do it is try to do it through contracts. I'm going to walk you through some of the steps of that, but I'm going to say with a big old disclaimer here, it's hard to do, and even if you follow these steps, the court may not say that you actually have a property right to concept. So I'm going to give you the best practices, but no, it is not one of those ironclad things at all. In the US, and I believe here too, that the law doesn't like protecting ideas because it is a building block of creative material, which is why under patent law, which is not relevant for the most part for our conversation, you have a lot of hurdles to jump through just to get a monopoly on an invention or on a use. So the best way to protect a concept, first, don't try and protect a concept. Try and write it out and copyright the thing. I will give you some more. Try and get a production company to sign a non-disclosure agreement. That's an NDA, and a non-disclosure agreement / non-circumvention agreement. And what that basically is that's an agreement which says, which the production company says, yeah, no, I understand it's your idea that you're pitching to me. We're not gonna exploit the idea without paying you something for it, without coming to you and doing another agreement. We get it. We will keep it confidential. You're not going to get a production company to sign this agreement. So as a matter of law, yeah, that might work. And it might work on a lower level, or rather on a, not on a Hollywood level. But the minute you're dealing with a Hollywood production company, they're not going to sign this. They are going to send you instead something called a submission release form. I talked about this during one of my lectures yesterday. A submission release form is a dueling contract in a sense. It says, hey, you're pitching to us, but you have to understand and agree that we hear pitches all the time. We may hear the same idea all the time, and you have to respect the fact that we may develop that person's idea and not yours, and you're not going to sue us for misappropriation of your property right. And so you're basically giving up, you're waiving your right to sue them for certain things. So the best thing to do is, prior to a pitch, yeah, maybe if it's a smaller company, maybe you can get them to sign an NDA, but for the most part, it's not practical. Try and avoid signing the submission release form. One of the things I often do is I push back and I say, well, yeah, my client could sign this, but there's a lot that I have to mark up here, and there's a lot that, why don't I just get him in the room with you and you kind of hear what he or she has to say. Sometimes that works, but if it's a bigger company, they will just say no. So just know this going in, that most of the time this isn't going to work. But again, if you're dealing with a smaller, non-Hollywood company, this can. Once you're in the room, try to create an oral contract. Now, there's a lot of nuance here that I will be skipping over, unfortunately, as to what it can and can't protect. But the most simple form of this, because copyright law requires written agreements to protect to transfer copyright, laws that govern concepts and ideas under U.S. law don't require a written agreement. Which means if you get into a pitch meeting, if you can get the other side to agree to this first, before you say anything about your idea, if you get them to agree to the following things, that it is your idea, that they'll pay you a reasonable amount if they use it, and that they will not disclose it to others with your permission. If you were able to get them to agree to those 3 points, and then they say, yeah, no, of course, we agree to that, please pitch, then you may, not will, may have created an oral contract. But your concept must be novel, original, not merely a variation of common concept. So let me give you an idea of what can't be protected, even if you did this. Years ago, before Bill Cosby was seen in the light that he is now, he was considered by Americans as a father figure for a generation as a result of the Cosby Show. However, prior to the Cosby Show, there was a young man named Murray who worked for NBC who pitched the idea of a very positive African-American professional family sitcom. And pitched it to NBC, and NBC said, maybe there's something there. Because at the time, all we had were shows that basically showed the working class, poor black experience in America, and nothing that showed the professional black experience. So NBC didn't do anything with it, and then suddenly the Cosby Show comes out, and here you have the Huxtables, and Bill Cosby's a doctor, and Felicia Rashad's a lawyer, and my God, this is a professional black family, and this is the idea. So even though Murray could show that he was in the room and that he was talking with them about this, the court said essentially, that's not a novel idea. That's not an original, it's a variation. I leave it to you to decide whether or not, from a historical film perspective, maybe that was a novel idea at the time, but the point being is that the court didn't want to to recognize that that was a valuable enough concept. So when you're pitching your concept, the only way it can be protectable is if it is really a new original concept. So if you're pitching something like, hey, it's like galactic forces and there's like a rebel, aliens and they're fighting against the big bad emperor. If you in your mind can point to other films that are like that, the chances are you're not going to be able to protect that as a concept. So if you want to pivot and try and protect a copyrighted work, or try and use somebody's copyrighted work and make a film out of it, I'm now going to shift a little bit to optioning a work, which is probably the big workhorse agreement that you're going to need to know in development. And this is the case where you have somebody who has written a script and you want to use that script. You want to use that script and make a movie based upon it. This is called an option purchase of a screenplay. We talked about it a little bit yesterday, and what this is it's two contracts in one. Sorry, wrong slide. Sorry, we jumped around a little bit here. Yeah, so it is, here we go, two agreements in one. An option, which is you're going to a writer and you're saying, hey, I want to be able to buy your script. I want to be the only one who can buy the copyright to the script so I can make this movie. Give me a little bit of time in which to do it, because I don't have the money right now. I got to raise the financing, so I can't pay you now. But give me an exclusive period of time in which I can be the only person to purchase these rights. That's the option side. You also have to negotiate the purchase agreement, because you have to say, okay, if I say, yeah, I want to purchase it, here's how much I want to purchase it for. If you don't negotiate the second part, if you only have an option, then what you've purchased is, in industry parlance, a worthless option. Because if you get financing and you come back to the writer and you say, okay, well, I want to purchase it, how about $10,000? The writer might say, well, gosh, you got a big fish on the line there, financier. No, I think $100,000 is more what I want, because there's no obligation to sell at a certain price. So what you need to know is you have to negotiate up front what that purchase would be, but that purchase is only triggered within a window of time that's in the option. It's generally 18 months or so. So what I want to do very briefly is just talk about some of the key things that should be in that option agreement. And sorry, I'm having some technical difficulties here. And I think the first place to look is the money. What I'm going to talk about for the next few minutes are financial concepts that are going to run throughout, not just the option purchase, but if you're paying an actor, if you're dealing with monies from distributors, here are some core financial concepts that you must be able to wrap your head around. You have fixed compensation. This means money that you are obligated to pay or to get, depending upon what deal you're doing. Very specific amounts of money that are not based upon whether the film did well, but it's based upon what you calculate. And this could be a fixed day rate if you're dealing with an actor. It could be an amount of money for a screenplay and an option purchase that's based upon what the production budget is, percentage of the production budget. But it's a very specific, calculable sum of money that must be paid. So we see the salaries, we see the option prices, purchase prices, and distinguish that carefully from the other side of the equation, which we producers love to offer to people, because we know we don't always have to pay them. And that's contingent compensation. Contingent compensation, as the word says, means money that's contingent, that is dependent upon something else, like the film actually coming out and making money. So deferred compensation. Deferred compensation, we see that a lot in services agreements where I'm hiring a crew member, where I'm hiring an actor, and that takes the form of this. Says,
no, your services are valuable. Look, I would love to give you $800 a day. Right now, I only have $50 a day to pay you. So if you're fine with me giving you $50 a day fixed income, when the movie makes money, I'll give you the per day rate of the additional $750. That's contingent upon the movie coming out and making money. So you have to be aware that there is a lot of if-thens before you even see the dollars. Interest on investments. If you're an investor, you're going to look to include 20% return on the monies that you put in, and they're going to require that before anybody gets any other money, before any profits. Bonuses. If the film does well at the box office by certain amounts, you can get some money for bonuses. If it gets an award, certain kinds of award, you can negotiate for bonuses. But again, it has to be in the contract. Residuals. These are monies that you receive if the film hits the TV network, and especially under union law, like SAG and AFTRA, they will dictate how much money the actors must get paid in residual payments. Royalties. These are based upon merchandise. The merchandise, if you sell an action figure and Robert Downey Jr. has 10% of the sales of that action figure, that must be paid in terms of royalties to the actor. And perhaps the one that we hear about the most is the all-important net profit. Now, we could spend hours on net profits. We won't, and I think maybe the accountants will go over a little bit more detail. But there's a lot of truth to the Hollywood saying that that net profits are almost never realized. And what a net profit is after the investors have been repaid their investment money plus that interest on the investment, and after all the expenses of the film are taken into account, including marketing expenses and distribution expenses, and after all the deferred compensation has been paid, basically after all the things have been paid, and whatever is left over, there's a very specific formula that's going to be in the agreements. That allocates the net profits. And on indie films, it is often rare for anybody to actually see money from a net profit. So my advice to you is, if you are, my advice to you depends on which position you're in. If you are an actor or a writer, I would say it's better for you to negotiate a higher fixed fee than it is to negotiate a better net profit position. The reverse is true if you're a producer and you're negotiating with somebody and you don't have the money in your pocket and you want to offer them a bigger bonus or a bigger net profit position. Sure, great, because that may not happen, and a percentage of nothing means you don't have to pay anything. And if the film does make money and realizes net profits, well, you at least by that time should have some money in your pocket as well. So to plug in very quickly, some of the things you're going to need to know when it comes to, if you're an investor, you're going to look to recoup 20% return on the monies that you put in, and they're going to require that before anybody gets any other monies, before any profits. Bonuses. If the film does well at the box office by certain amounts, then you can get some money from bonuses. If it gets an award, certain kinds of award, you can negotiate for bonuses. But again, it has to be in the contract. Residuals. These are monies that you receive if the film hits the TV network, and especially under union law, like SAG and AFTRA, they will dictate how much money the actors must get paid in residual payments. Royalties. These are based upon merchandise. If you sell an action figure and Robert Downey Jr. has 10% of the sales of that action figure, that must be paid in terms of royalties to the actor. And perhaps the one that we hear about the most is the all-important net profit. Now, we could spend hours on net profits. We won't, and I think maybe the accountants will go over it in a little bit more detail. But there's a lot of truth to the Hollywood saying that that net profits are almost never realized. And what a net profit is
is after the investors have been repaid their investment money plus that interest on the investment, and after all the expenses of the film are taken into account, including marketing expenses and distribution expenses, and after all the deferred compensation has been paid, basically after all of the things have been paid, then whatever is left over, there's a very specific formula that is going to be in the agreements, that allocates the net profits. And on indie films, it is often rare for anybody to actually see money from a net profit. So my advice to you is, if you are, my advice to you depends upon which position you're in. If you are an actor or a writer, I would say it's better for you to negotiate a higher fixed fee than it is to negotiate a better net profit position. The reverse is true if you're a producer and you're negotiating with somebody and you don't have the money in your pocket and you want to offer them a bigger bonus or a bigger net profit position. Sure, great, because that may not happen, and a percentage of nothing means you don't have to pay anything. And if the film does make money and realizes net profits, well, you know, you at least by that time should have some money in your pocket as well, by the other net profits. So to plug in very quickly some of the things you're going to need to know when it comes to pre-production legal issues, because I want to leave time for Q&A. When you hire cast and crew, especially in the US, we have a number of different laws that you have to be aware of, from the contracts we do to the unions we deal with, like SAG-AFTRA or the Writers Guild of America, to the federal and state labor and employment laws. So it's almost as if you need to be a lawyer to sort this all out. The easiest thing from a producer perspective are, if you're dealing with a professional performers union like SAG-AFTRA, which is the big film and TV union in the US, you are obligated to sign their agreements, and you are obligated to deal with whatever minimum terms they dictate. And what that means is, if they say that you must pay, based on your budget, your actor at least a certain amount, even if you and the actor agree that they'll only do it for $50 a day because they love you, they love the project, doesn't matter what's in your contract with them, the union contract minimum will control. So it is so key to understand this, and SAG does a it does an all right job when it comes to educating producers. The SAG Indie website is a great resource, but one of the issues I've had that's particular to the Caribbean, especially with some of the other islands I've dealt with, is that on the indie film level, SAG's not as willing to get involved as it is on the big budget film level. So I don't know if you personally have had those issues as well, but it can be very hard on a low budget film to work with Hollywood SAG actors unless there's a lot of assurances given that the monies will be paid or put in what's called an escrow account. And so it can take a little longer to get a SAG actor. One of the things that we were talking about during the break that I think may help out here, if I was giving this talk 5 years ago, I would stress the absolute importance, the critical value of having a performer that people recognize as part of your film. Note, I didn't say a star. It doesn't have to be a Brad Pitt or Mahershala Ali. It has to be somebody that, as you're scrolling past your Netflix queue, you go, oh yeah, wait, isn't that dude from, what was that? Oh yeah, that dude. It literally just has to be on that level depending upon your film. Obviously the better actor, the better. But because of the past few years, there's been a real push in Hollywood and the comic book publishing industry to hear a diversity of voices and narratives that aren't the typical US narratives. There's a much more of a willingness to see indie films that are representative of other cultural narratives and other cultural stories, especially when they are told by the people themselves. I think there's a long overdue Hollywood has kind of reached a tolerance level of yet another white dude like casting somebody in dreads, smoking pot, and saying he's a Jamaican, right? I think we're hopefully done with that to a large, degree, which means that there's such a vibrant, idiosyncratic nature to Trinidadian culture, right? Your mass works, your carnival. There's a lot here that if told in your own voices, that plugging this back in, I don't know that you'd necessarily need to fly down Marsala Ali to play a Trinidadian, So I'll leave that up to you, because this is just really based on a couple of days of what I'm seeing here and what I see Hollywood being receptive to. So, maybe the SAG-AFTRA bumps are not as problematic as they would be, 5 years ago. But if you're trying to create a film that looks and smells like a Hollywood blockbuster, which really, it could be set in Trinidad, it could be set in Kuala Lumpur, it doesn't matter. Now you're going to have the issue of, if it's not steeped in your culture, and it's going to be a little tougher to set it up unless you have that, I think, cultural hook. Again, this is just anecdotal, but for what it's worth, it may be easier the more you're telling stories that are very particular to your narratives here. If you're doing a services agreement, and these are deal points that are true, whether you're dealing with actors, whether you're dealing with performers, you need to have the following in writing. There needs to be a provision which talks about what this person is doing. We call this an engagement provision. How exclusive are they to you? If they're an actor, you don't want them running off and working on something else when you're in production. You want them to be exclusive to you during the days that you define in production. I had an issue with this a few years back on indie film that cast people that you would recognize, and one of them got a really big part in a TV show, and they just didn't show up on set one day. And the agent tried to call me up and play nice and ask if I would just rearrange the very expensive shooting day so the actor didn't need to be there, and I had to threaten to sue. And because I had this provision, I was able to do that. You have to have the granted rights. All of the stuff we said for the past 2-3 hours now about granted rights, you have to have people grant your rights. And even though under US law there's no right in a performance, we've all been on film sets. How many times does an actor improv a line and you're like, whoa, no, that's great? Or an actor comes up with some creative material that could be copyrighted material. So you need a grant of rights of the actors. Certainly for the crew, it's a very collegial, collaborative process, and people always put in creative input. So you need to make sure all those rights are taken care of. What is the compensation? How much are you paying them? What is the credit that you're giving them? The priority of credit, the where it comes in the credit roll, the size, the media. And all of these obligations, by the way, especially the credit obligations, have to be agreed to by the distributor. When you get distribution, because it's going to be the distributor that's doing the copies of things for different countries, they have to agree to use your credit language. And quite frankly, if you're dealing with SAG, AFTRA, other unions, they're going to be credit requirements that you will find yourself in breach of. Are you taking care of any of their expenses, hotel, travel? What approvals, what likeness approvals, maybe not as many in Trinidad, but certainly in the US, can you use their likeness for merchandise? What publicity are they allowed to engage in? So here, the US practice more and more is to restrict people's ability to use social media to talk about the project. And that's in large, it's largely because after people may become acrimonious, especially if a film shoot is a hard or arduous film shoot, and you can have people going into Twitter and doing whole flame wars. So you want to restrict their access to do that. The representations and warranties we talked about. When can you fire them or terminate them? And one of the big issues in the U.S. now are the increasing frequency of what we call morality clauses. So if you have a performer or a crew member who has engaged in activity that may be sexually harassing or criminal behavior, something that brings a certain level of disrepute to themselves, you may want the ability to terminate them. Now, technically speaking, if you didn't have that in there and it didn't absolutely affect their job itself, you'd have a harder time terminating them because of that. So if they showed up on set, they didn't harass anybody, there was no criminal activity on set, you would have a harder time terminating them. That's why you need that in here. And it is very, especially in the U.S., I don't have the sensitivity to the Trinidadian culture, but right now in the U.S., those sorts of issues are very hot topic issues. So if there's somebody who had, Harvey Weinstein, I'll just leave it at that. You will need the writers, producers to assign all the rights, to transfer these rights to a third party, or to transfer some of them to a third party, like a distributor. What remedies? Now here, Anthony mentioned something before, very key: venue, jurisdiction, what laws apply, right? And what remedies do you have? The one thing that I recommend under US law is that you prohibit everybody from seeking what's called equitable relief, which is a fancy way of saying, going to court and saying, Your Honor, money can't compensate me. I've been damaged so badly, I need you to stop distribution of the film. So, and that can happen. For instance, if you blow somebody's credits, right? Or if you change the work in such a manner, I'm going to go out on a limb here and say that if it violates a moral rights provision under Trinidadian law, I'm going to guess you could probably seek some equitable remedy, right? Yeah, so you're going to need to get a series of waivers and have them waive the right to seek equitable relief and just sue you for money, because that way the film can still make money. Under U.S. law, you couldn't take away all of their rights to sue, but you can take away the right to equitable relief. All right, now I have like 10 more minutes. So do you have just literally in 2 minutes? I went through a lot of stuff now. So is there like a 2-minute chunk that you can weigh in on that before I pivot to production?
Well, I'm glad we were talking about the jurisdictional point, because I think in our contracts, in my experience, dispute resolution is critical. You're going to have, as a producer, all kinds of disputes. Disputes with your writers, with your performers, with your financiers. So in the old style, you would go to court, sue for breach of contract, and then everything shuts down. Filmmaking process stops, you're waiting for court resolution. What I recommend is within every agreement, you have a sort of sequenced steps to dispute resolution. So at first instance, parties commit to use best endeavors to try and resolve the dispute amicably between themselves. Failing that, you go to mediation. And failing that, it may be that you want to go to arbitration rather than to a court, because arbitration is private, courts are public, but arbitrations can be expensive. The other thing is that you don't want to have a situation where the work grinds to a halt while this dispute is resolved. So you need to have it as an ongoing thing, that as disputes and differences arise, you try and deal with them expeditiously. So that will be bound by contract, that you have agreed that we will try to resolve our disputes in a certain way. Of course, you cannot preempt a court, but you would say that that is a measure of last resort. Now, as we talked about earlier, you're doing a film in Trinidad, but you're using somebody in the States, and there's an agreement. If you don't set out choice of law, the governing law and the venue, you're going to have problems. Or you may actually be signing a contract in which your law does not apply. It's US law, and it has to be in that particular jurisdiction. These are things you need to be very mindful of, because they will be fundamental. So for example, if US law applies, well, forget moral rights, forget neighboring rights, because they don't recognize that under their law, and vice versa. The young lady in the back there had asked about company or partnership. This is for me, governance is critical, because And it starts with your foundation. Are you going to be operating as a partnership? Are you operating as a company? Are you operating as an individual, as a sole trader? I want to suggest to you, because I know filmmakers are all about the creativity and the impact of the film, but I would like to suggest that the business of making the film is just as important as the actual film. So you need to make sure that you have right governance in place. And that also deals with management aspects. You need to realize that the film making is a process. It's where talent, rights, and money and dreams all meet. The process, concept, idea, getting finance, pre-production, production, post-production, distribution, exhibition, each segment we could spend days on. But you need to have the long-term view. Just don't focus on one thing. Besides legal contracts, there are other issues. Finance. We don't have angel investors in this jurisdiction. You will probably have to go to a bank, and our banks are risk averse. They're not financiers. They're a bunch of accountants. They will want security and all kinds of things. So then if you're looking for now equity financing, you need to understand what goes with that. Accounting, marketing, promotion, management. For me, the producers are at the heart of the process, so you need to understand how your IP rights can be used strategically. You must be able to collaborate, to engage, and to motivate. Then we talk about film development, and again, managing risk. How to avoid cost overruns, how to stick to your budget. You need a certain amount of discipline. You need to do your flow charts and to crunch out your spreadsheets, right? So there's so much more that we can pack in here, but I mean, I know it's really challenging for Thomas, because I suspect he could go on for days and still not cover all that he wants to cover.
I teach this all literally in a year, at film school. So I'm trying to give you literally the 20,000 foot view. Let me just jump on one thing that you said, and there's so much. So yes to everything you said, but especially one of the things that can get you into hot water so often, and that is when you're raising money. In the U.S. especially, and I'm going to guess you probably have something similar here, we have a lot of laws that govern how you can take people's money. And the minute you are taking people's money with the promise that they will make more money if your film makes money, but you don't have an absolute obligation to repay it. In other words, the way we all want to raise money for a film, right? You offer net profits, you offer a potential to make a profit. The minute you do that under U.S. law, you're dealing with what we call securities laws. Same thing as a stock and bond. Same thing as what's on the stock market, right? It's those same groups of laws. Now, as a result, and I really don't have time to get into it, but I do believe the accountants are going to be talking about this today. But the thing is, at this point, you have to stop. You have to stop before you even make an offer to somebody. You've got to consult an attorney who knows this stuff, who can draft very specific and precise legal documents, and to put your, what's called an offering, through the very specific and particular process of either registering it with the securities, the SEC, Securities Exchange Commission in the U.S., or exempting it from registration, somehow proving, hey, no, it falls under one of these very specific Reg D, not that I'm going to go into that, but one of the very specific exemptions that we have. All this is by way of saying that it is so critical to do this because, and here's the big scary part, if you don't, and you just take the money and you say, don't worry, dude, I'll get you money. The film didn't make money. What are you complaining about? Under U.S. law, you can then be sued and may, at the best case scenario, only be required to give back the money. That's the best. But there are civil and criminal penalties on that, so you could actually incur jail time. So it is so fundamental that when you're doing it, if you're promising somebody a profit, and if you don't make money, they don't make money, you have to deal with securities laws on this. But I do want to encourage you to take the accountant's track on this, because I think they're going to go into this, and I wish I had more time to go into it, but we don't. So I'm now going to jump ahead to a couple of key targeted areas in production, post-production, distribution, and then open it up to Q&A. And I'm happy to deal with targeted questions on a lot of the areas that unfortunately we don't. If we're going to do this again, I'd like to actually carve out a whole day to do it because there's so much here, and maybe you and I can talk about how to do this next year for a whole day. But let's jump into some key legal issues in production. Depiction releases. These are those forms that, that we require in the US to get somebody's likeness to use on film, and it is required by the production studios, and it's going to be required by the TV networks. And basically it says, yeah, you can use my likeness in the film, and I agree not to sue you for certain things. And it's not the same thing as an actor's agreement. It is a very one-page document. But it does need to be there if you see somebody on camera that is distinguishable. Location releases. These are permissions to use actual locations. And they're especially important when it comes to working commercial establishments like a KFC, that the one that didn't burn down in our previous hypo. If you want to shoot there, you need permissions to use their logos and their other intellectual property and what we call trade dress, the distinctive look and feel of a business environment that has a trademark value. Shooting permits. These are different in the U.S. This basically is permission from a municipality to shoot in that municipality. And that differs in the U.S. It runs the gamut. In New York City, if you have a camera in hand and you're not putting down sticks, you're not using a tripod, you're not blocking traffic, you can pretty much just shoot, just run and gun, as they say in the U.S., and you don't actually need a shooting permit. But if you're blocking traffic in New York City, then you have to go get a shooting permit. But in other jurisdictions, just shooting something, you might own a house, let's say in New Jersey. And even if you want to shoot in your own basement, they will require by law for you to get a shooting permit and to pay them $500. So it runs the gamut of depending upon where you're shooting. On-set intellectual property. I will be dealing with this in a little bit more detail, but this is where those copyright concepts come into play, and issues like fair use. I won't go into all of the legal nuances of it, but I will just give you some guidelines to pay attention to. Insurance, and I've heard from people that this is not, the entertainment insurance industry is not as developed here. So there are a couple of insurance types that you're going to need to be aware of. One of them I've referenced before, errors and omissions insurance. And what that is that's insurance that protects you against intellectual property lawsuits. And you have to work with an attorney, because what the insurance carrier will say is, okay, you want us to basically pay for your insurance defense if you get sued? Okay, well, show us all the contracts you have. You're going to look at this and go, dude, if I had all these contracts, I wouldn't need insurance, which is where the attorney comes in. So one of the things I teach this, and I actually do a lot of it, is I then, when I see this, I will say, but Ms. Jones didn't need to have a contract here because under the law, a contract isn't required in such and such a situation. I can argue fair use. I can say there's no right of privacy. And that's where we sort of make legal arguments to get you that insurance, that bound insurance. And you have to work with the local police, fire department, anytime, and this is probably just common sense, anytime you're using firearms, anytime you're blocking traffic, anytime you're putting on a uniform, and I understand from talking with you yesterday, you can't do that here at all, like an army or police uniform, right? Is that right?
Well, actually, under the Summary Offences Act, wearing a military uniform, having and under the Firearms Act, having an imitation firearm is an offense. Now,
if only someone would change it. If only some wise attorney would change this.
But we did, when it came up in Parliament recently, I did push for an exemption for theatrical use and filmmaking. So you do have that little carve out. But ordinarily, as you know, people have been arrested just for having a bullet, just for coming through the airport with camouflage gear. The point Thomas is making, though, is you're operating within a context of national laws. You need to be aware of your laws, obscenity laws, sedition laws, libel laws. All of these things have your attorney on site to advise you and to kind of ring fence and protect you.
I know that especially when you you're dealing with things like uniform services, Canada has pretty much the same kinds of laws. So if you're in Toronto, you can't use Toronto PD uniforms on screen. You can't have someone who's not an officer actually wearing the uniform. So what we've been able to do up there is create a uniform that is similar to it. So the logo is not the same. There are certain differences. So technically, it's not the same thing. And then even with the firearms, what they've been doing now is because you could use color correction, right? You just make sure that the weapon itself or the object itself, it might be a little bit gun-like, but it's bright orange, is clearly a toy, and then in post you try to fix.
Oh, that's interesting.
You try to fix it. And a lot of really low budget producers, especially for like web series and that kind of stuff, who also don't have the money to, because to go get the licenses for a firearm on set or even any kind of waiver, that's money. You have to pay a pay duty to be there all day, every day, and those guys aren't cheap. Those pay duty policemen, right? And so what you do is you simply
shoot the orange gun and then color correct it.
Yeah.
Right. So let's talk about some other issues on intellectual property on the set, again, very, very quickly, and we can answer during the Q&A some specifics on this. But it comes as no surprise if you're shooting someplace at a public space, you're going to see a lot of intellectual property, copyrights, logos, things like that. And the question always comes up, all right, how do you do that? Do you have to get permission from every single person? And I would say the answer is you don't necessarily have to get permission, but you have to analyze every single thing to see whether or not you need to get permission. I will give you a few rules of thumb. U.S. treats the fair use issues, we call this fair use, whether or not you can use somebody's copyright without their permission, and whether or not you can make use of a trademark for non-commercial purposes. We treat these in very specific and idiosyncratic ways, but given the time we have, I just want to, instead of going into the nuance of it, I want to just give you some rules of thumb. So there's greater likelihood that a copyright use, and I'm stressing this word now because you've got to analyze trademark a little bit differently, especially under U.S. law. But if you're showing something only briefly on camera, if it's not the focus of the scene, so if it's a poster that would automatically be there already, and you're just somebody's running past it, it's more likely to be okay. If you're only using a portion of it, you're not shooting me in front of this backdrop right here during the entirety of this presentation, that would not be okay. But this is for face-to-face educational purposes, so maybe it's okay, and I'm going to presume that the good people at FilmTT have okayed the fact that they can use their logo in this presentation. If under US, and this may be more specific to US, if you're commenting and criticizing, if you can make some fair use argument that's based on the First Amendment that we have, then we have very broad rights there. If your film is educational or informational or a documentary, and this is part of the world that you're talking about. So if it's the, we're going to downtown Port of Spain, and we're going to interview some people and they can talk about filmmaking in Port of Spain. If that's my documentary and you're walking through and you're talking about the different places, and here's the KFC that burned down but the IP stayed, then in those situations you can use it because it's related to the topic at hand. If you're unlicensed work, in other words, you're using somebody else's work, if it's not going to hurt the value in the marketplace. And here the court's going to look very specifically to, are you trying to replace it? Let me give you an example of what not to do. Let's say there's a very popular soca singer, and you want to do a documentary on soca. And you include the entirety of this person's musical performance, and you shoot almost a music video in that film. They might be able to argue, and maybe I shouldn't use Trinidad as an example here because the Trinidadian laws would apply, but if it's in America and you have the same situation, that singer would likely, and that person who owns the musical copyright would likely be able to argue that your use is supplanting their music video use. So if it's a little snippet of it, fine, and we're going to, please.
We don't have the fair use doctrine in Trinidad and Tobago. We have very specific exemptions to the Copyright Act for like teaching purposes, for newsworthy purposes, and so on. Fair dealing is, again, fair use, fair dealing. We don't have that. But I also want to say that you don't want to be giving people freebies in your film. Product placement is a great way of earning revenue in your film. So I am always very careful to make sure that when you're doing your shooting, you're not advertising anybody's brands or products subconsciously or unconsciously. It's in fact quite deliberate, and whatever you do put out there, you have a permission, and hopefully you get some coin for it.
And I'll just springboard off that very briefly, is that under U.S. law, if you do product placement, it must be disclosed, and especially if you're putting it on television, because television networks have very specific deals with advertisers, that if you spend a lot of time doing Coca-Cola and they have a big ad buy from Pepsi, they're not going to want to see that. And there are actual federal laws on point about how you must disclose marketing and advertising in the U.S. Let me just pause for a quick sec. Right now it's 5 to noon. How I don't want to butt up against. We started a little late. When should I?
I think we can go. 12:15 is our appeal. 12:15 is our yeah. So 12:15 is our time to stop. Maybe we can go until about 12:20 because I think we have a.
Okay. Does that throw off anybody's schedules if we go a little bit? If we look good? I just want to make sure to give you guys the value. Okay, so then what I'm going to do now is I'm going to pivot again, and a lot of this stuff I'm sure we're happy to answer very specific questions. But let me go into music permissions, because this is where the rubber meets the road. Yeah, here we go, here's the good stuff. Okay, all the stuff we talked about with copyright, that was simple. Now we get to the hard stuff. And that's because in every piece of recorded music, there are not just one, but 2 copyrights that you have to deal with. You have the copyright in the recording itself, and you have the copyright in the musical composition. So those of us who play instruments, if you go to Guitar Tabs, you have a music fake book or something, that's the composition, right? The recording, that's self-explanatory. U.S. law, and it is changing quite literally as we speak. We have a new law in the books called the Music Modernization Act, which deals with recording and where you can use it. So it's right now music law in the U.S. Is a very rapidly changing area, especially when it comes to fair use and to the extent that you can use people's work without compensating them for it. Let me just give you the bottom line from the producer, is that of all the areas that I see people sue, music is the #1 area, right? So I don't know if, you guys have been following, what's happening with Ed Sheeran, or a couple years back with Robin Thicke and Blurred Lines. There is a through line of don't mess with the estate of Marvin Gaye. I will tell you that right now, because they will come at you. So the bottom line is get your music permissions. There may be some carve-outs, as I said, if you're doing a documentary and there's somebody walking down the street and there's some street musicians playing as background. But the minute it's front and center, the minute you're using it as a soundtrack as opposed to the natural sounds of the environment you're in, the minute you're focusing on all the stuff we just talked about, you got to get permissions.
So as you know, I am for COT. And COT represents virtually all the local musicians in Trinidad and Tobago. And COT recently, in addition to owning all of the local content copyright, they are the exclusive licensee for ASCAP, BMI, PRS. So they basically control all foreign content music. They have a responsibility under the reciprocal agreements to obtain license fees. So COT will come behind you if you use music without permission. Music is a form of property, it's copyright. COT also recently signed an MOU with IFPI, so they also now represent the rights of the sound recorders, the owners of the sound recordings. So yeah, get your copyright license.
Mm-hmm. So what rights are we talking about? We're talking about copyrights, obviously, but there are some very specific names for the licenses that you're going to be using, and here are the 4 big ones. You need to get what's called a synchronization license. And a synchronization license means the right to, in U.S. parlance, put this in timed relation with the audio, with the video of your film. So in other words, to match the music with the video. You need to get the master use rights. That is the right to use the actual recording. Under the U.S., it's a little tricky because depending upon who you're dealing with, the person who owns the composition are the publishing companies, the music publishing companies. The people who own the recordings are the record companies. Sometimes there's like 20 different publishing companies because you have a band of 20 people and they each form their own publishing company, so you got to go to all of them. Sometimes they folded it into one entity which deals with these rights. The master use rights can be owned by the record company. The performance rights, I'll give you, it's actually easier on an international level because you should always get performance rights. In the US, we have some carve-outs that it's just better, since it's going to be distributed internationally, just get the performance rights and get them from both entities, both record company and...
Just to clarify, when he says performance rights, we're talking about the rights to publicly perform the work as opposed to a performer doing a performance.
Yep, thank you. And get the videogram rights. That's an old term. It's like sheet music, piano roll. Videogram is the physical embodiment of the movie, like a CD is a videogram. If it has the music in it, you're going to get the right to be able to sell physical units of this. There are other rights, but those are the big ones you have to get. And the terms you're going to need to negotiate, you're going to negotiate the length of time, which is also called the term. It's one of these things I hate about the law. Like, we talk about legal terms, right? Legal, types of clauses. But I can also say what is the term of the term? And what that means is the length of time. So here I'm talking about the length. How long can you get it for? What territories does your use cover? In what media can you use these rights? What's the fee? Can you make modifications to the composition and the recording? It's typical to be granted the right to edit for time, but if you want to do something interesting and creative and create another version of it, that's going to be much harder to get the rights to do that, and you're going to have to pay more money. The all-important representations and warranties, here also you need them to rep and warrant that you're dealing with the right person. That's called a warranty of authority. You need to make sure that the person who's saying, yeah, I get the rights to use this song, that they're the right party to deal with. And if you get sued, you can pass the buck on to them. And what credits do you need to give them? There are variations on all of these things, and the ability to change up the type of license after a while. So very often what people will do is they'll say, let me negotiate and just pay you for what's called a festival license, because I don't have a lot of money right now, so let me just do the easiest bottom level license from you guys. And then if I get a distributor, then I can pay you more money to use this as it's distributed. But all those terms, the amount of money that you then pay for, all of those have to be negotiated up front. Right? Because you don't want to be over a barrel and have them dictate terms to you once you have a distributor on board. I would say one last thing about post, give a couple of comments about distribution, and then really open it up to the Q&A. And the one thing I want to say about post before we completely leave it is that you have to take a look at your credits provisions. Make sure that you are absolutely giving people the credit that you say that you're going to give them. It is one of those issues that will get you sued, especially if you're dealing with an actor who has an agent. The important things for those actors are the money that they get and the credits that they get. So do not mess with either one of them. Yeah, the right of attribution.
Performers also have moral rights.
Yeah, we don't have that, but you don't want to be sued. So I'm now going to talk through. Let's say you land a distributor. Right? What does that distribution deal look like? And let me get over to that slide. And then once that is done, I'm going to open it up to Q&A. But I want to at least leave you with some deal terms on distribution. And here we go. Okay. When you distribute something, when you work with a distributor, their key role is to take your film and to put it in as many different markets as they can for as much money as they can, and then to give you the rest. What they do is more than just put it to exhibition places like movie theaters and television networks and in-flight movies, but they also handle the marketing and advertising part of it as well. And they also dictate how the trailers are made, and they also decide whether or not they need to edit your film because it may violate some obscenity laws or something in another country. So as a result, you're giving them broad rights. They also, depending upon the distributor, may want more than that. If they're a hybrid production company / distribution company, they may also try and take the rights to make your sequels or make your merchandise and make other things too. So it's a more nuanced discussion, but you have to sort of see whether or not their ability to sort of carry out, to effectively exploit all the rights that they want from you, whether or not they can prove that they can make this money. But the deal terms at their heart, you hopefully want to negotiate what's called an advance, and that is money that they give you with the expectation that that the film will make money. But when that film makes money, the first things they do is they pay themselves back that advance. So, you know, one of the things that gets filmmakers into hot water, and musicians especially, is they don't understand the difference between an advance and a royalty. An advance literally is we're giving you money that will be paid back. So your advance comes out of your royalty stream. You're going to carefully define what the rights are that the distributor gets, in what media, in what territories, for how long. What rights do they have to edit? As I said, it's typical to grant them the right to edit for censorship or to violate laws. It's typical to give them the right to edit for time. But you may want to introduce things that allow you some modicum of control and take this into account, actually, well, when you are shooting the film. One of the things that you often see in trailers are you see shots that are not actually the shots that you see in the movie. So let's say there's an action adventure movie, and you have some guy pounding the table saying, "We need to scramble those fighters right now!" And it's really big and it's really over the top. The actual scene in the movie, he might be a little bit more sedate. We got to get those fighters right now. And that's because they know when you're editing the trailer, it has to be big, over the top, explosive. So make sure to keep that into account, and you may, identify. You guys are the creatives, right? So identify what are going to be likely those key moments in the film, and shoot it again for the trailer, and have them really go over the top, And because of that, you're not, you're giving the distributor, when they edit the TV commercials and the trailers, you're giving them enough stuff to work with, and it really sells. You're going to give them exclusive rights, right? This is the importance of the copyright chain of title stuff. You're giving them exclusive rights to distribute in these areas. They're going to have advertising and promotion rights. Now comes the fun part. How you get paid, but from their perspective, more importantly, how they get paid. If we had more time, we'd go through the how the money goes from the consumer's pocket all the way into yours. But suffice it to say that the film theaters and the networks, they have a cut that they take out. But the first thing that distributors take out, and there are different flavors of distribution deals, but there's something that they call distributors' recoupable expense. And basically that means, what are the things that they can pay themselves back first out of the monies that come in? And make no mistake, I don't care how much money you spend on your film. You don't get paid back first, they do. and they will pay back things like the costs they spend in marketing and advertising and going to film festivals, and if you're doing actual film itself, costs of the negatives. So there's a lot that comes out of this, and this is one of the big reasons why net profits are often never realized, because the distributors take such a huge chunk. They then get to pay them back again, depending upon the kind of deal. They then pay themselves a fee. So yeah, this is different from paying back their expenses. This is paying themselves. And again, that often comes out before you get any money. You should always put down any time there's any time that you are relying on somebody's promise that the accounting is a certain way. You should always put in an audit provision allowing you to look at their books. Credits. Here's where you must make sure that they are obligated to use your credit rolls, or else you will get sued. What happens in case of default? And this is not just what happens if they don't do the things that they're supposed to do, but it's also, can you give yourself an out? One of the things that I like to advocate for is if the distributor says that they, let's say, distribute well in Europe and in Asia, but they didn't do a good job in Asia, but they did well in Europe, you might want to put in certain thresholds and say, okay, if you don't make this amount of money in Asia, I get to pull back the right for you to work in Asia and take that to another distributor. Representations and warranties, we hopefully all know what those are at this time, but just know that if they get sued, you will get sued. What deliverables are you giving them? What physical and legal deliverables? Legal deliverables are a thing, and this is where the chain of title comes in. You're going to assign these rights, which again plugs back into, see how many of these clauses pertain to IP. And finally, they may have errors in emissions insurance, but many times they will rely on you to have it and to add them as somebody who is insured. So a lot there. But what I'm going to do now for the rest of the time is I'm going to open it up to Q&A, because we have a hard out in 10 minutes. So let's open it up to some questions for the next 10 minutes. A lot that we didn't cover. I'm sure you have questions. Anybody? Yes.
When you were talking about the oral agreement, how do you ensure that? Is that just based on people's word, or do you secretly record it? Do you ask to record it?
I think the politics of the situation. Right? I mean, there are some states, and whether you can record without somebody's consent is a state-by-state issue here in the United States. But I think the better practice, is not to sound like a lawyer, right? The minute you sound like a lawyer, the minute you kill it. So I would at first try and get it, because, hey, just before we get started, I just want to I'm so excited to do this, but I just want to make sure we're kind of understanding each other that, all right, so I'm going to tell you the idea, and if you like it, you'll buy it from me, and I mean, obviously I'm here because you like you want to hear what my idea is, and I guess we'll work out whatever whatever's reasonable, right? And you're not going to tell anybody, right? Because I want to be able to. So you see how I sound like a real gushy, enthusiastic producer guy, and not like the evil, black-hearted lawyer, as opposed to the kind, white-hearted lawyer that Anthony is. So that's important. The other thing is to send them an email afterwards that memorializes it.
Something on that, because one of the takeaways I really would like you all to have is IP is at the core of the film industry, and contracts are fundamental for making it work. Now, as a people, we don't like contracts. We have a mistrust of lawyers. We find contracts very aggressive when somebody says, hey, read my contract. It's off-putting. It's inconvenient. You have to go and find a lawyer to draft this sort of thing. But they are fundamental. They are absolutely necessary. And what's worse than having no contract is to have a badly drawn-up contract. All right? So first thing. Now, the oral agreements, yes, an oral agreement can be enforceable if it's a 1 or 2 point deal, but then you're going to have proof as to who said what exactly was agreed. Yeah. So oral agreements though enforceable, is more theoretical than practical. You can have an agreement that's partly oral, partly in writing, and you can have an agreement that's just based on performance, that you acted and behaved in a certain way. In our law, an agreement to be binding, there are certain key elements, often acceptance, consideration that something was exchanged or given a value, and intention to have legal relations.
And it's the same in the U.S., by the way.
The other thing is, in addition to really getting contracts and properly drawn up contracts, you need to remember that contracts are living documents. You don't gain rights and draw up contracts and then put them in a drawer. You need to manage your contracts, right? And I think, it surprised me when I was counsel for the film company to see how many people were doing films where the legal component was absolutely, if not non-existent, minimal. We need to change that mindset, all right? And I think in changing it, we also have to be careful, because now what I'm seeing is a kind of a free-for-all. People are doing contracts, they pull this one off the net, they get this one from some lawyer, they get this one from some friend. We're going to need to get some kind of consistency. We are not a mature industry like Hollywood, but we do really, and we don't have like SAGs, the Screen Actors Guild, where one of the benefits with them is that you have standards, you have consistency. So maybe we can, through the FilmTT, get them to do some boilerplate agreements, some standard contracts that we could build on. You could always bespoke it, but we need to have some basic things that everybody is comfortable with.
Other questions? We have 5 minutes. Yes.
When it comes to international production, is there a consensus about which jurisdictions are more favorable for producers and which have more protective rights when it comes to IP?
So the question is, when it comes to international productions, is there a sort of preferred place where? And I guess I would answer that is it depends upon the perspective is typically that of the production company, right? So from the production company's perspective, it's a pain to deal with moral rights. So and because Hollywood is the big driving engine, a lot of times you're going to have jurisdiction in Hollywood, but it also depends upon the money. And if you're getting a lot of financing from Germany or Canada or wherever, they may require, as a result of those production incentives that are built into the government, a certain amount of the filmmaking to be done in that country. So, so it's a little bit of a morass, especially depending upon the laws of that country. If you bring in a contract which says everything is California, everything is New York, is U.S. law, some countries may have the production incentive saying, whoa, 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 hold on. We need to have more control over that. Do you have a take on that?
I can see why neighboring rights and moral rights could be off-putting for producers. For me, I think, there's a pie here. Everybody should have a fair slice at it, but it's how you manage those rights. Now, I've also seen a jurisdiction like Canada start from scratch and develop a very sophisticated, very successful film industry. I think we have the potential and the capability to do that, but it needs to be tackled strategically, holistically, and we need to bring everybody up to speed. I think there's room in the space for performers, for writers, for producers, but it can't be a free-for-all. It needs to be really done in a certain way.
And at the end of the day, if you're looking to the U.S. for money, U.S. investors need to know that they have all the IP rights and that they don't have to worry about these other rights issues. So if that means making sure that the contracts are drafted correctly under Trinidadian law and having the right waivers of the moral rights, then that's great. But they need to know that if they want to do another edit of the film 5 years down the line, that the Trinidadian producer or writer isn't going to object and say, whoa, that wasn't my creative vision, right? And so that's really what's driving it. Okay, other questions? Yes?
I have a
Question. So if your crew is mixed, like if you have part of your crew is local, part of your crew is American, and let's say it's a local production, like so far as Trinidad, but then your distributor is French or American, which jurisdiction are those contracts going to fall under?
Well,
Is it going to be a mix of
it's a,
contracts using Trinidad law and then contracts using American law?
it could be. I mean, it depends upon which contract we're talking about. If it's the production company doing it, they may try and have everything under U.S. law. I would guess, and Anthony could probably weigh in, that if I'm employing somebody in Trinidad, I'm sure Trinidad law would have a lot to say about whether, to the extent that I can say U.S. jurisdiction controls that. I don't. But the distributor, if they're in France, they're going to dictate where the forum is for that. So the overarching takeaway here is that you may be bouncing back and forth between different between different jurisdictions.
I think the first step is to be aware of the potential for risk and these issues. But if I were a producer and I were bringing in foreign actors, I would want them to be signing my contract.
Using Trinidad.
Trinidad law, governed here, dealt with here. Because what's the sense of having to go to California to deal with the Screen Actors Guild and their procedures and rates and all of that? The other thing is, when you are bringing in foreign talent, you have to deal with things like work permits. There's a whole host of things that you need to have a little checklist, and visas and all these different things. So again, this is where you need to have almost like a set of checklists under each of these categories.
Yeah, and
Can they insist, like could their agents insist or their managers insist that their contracts are run by U.S. law? If you say, okay, well, we're going to use the laws of our country, I'm the producer here, can they then say, well, I don't think your laws or your system or your structures as well developed as ours?
What's more typical? So could they say that? Sure. And look, there are a number of agents and managers on the panels, so I won't disparage them in general. But agents will say a lot of different things and pound tables very, very hard. But what I'll say is more typical. If they don't have an assurance that the country they're dealing with will deliver whatever it is, they will put monies in escrow. And what that is, that's a special bank account so you're going to have to prove up, that you have this money, not by showing a bank statement, but by taking the money and putting it in a bank account. And that bank account, if you can think of like a virtual key, is unlocked the minute something happens. Like the minute the actor signs the deal, they might get a portion of that money. The minute the actor sets foot on Trinidadian soil, they get another. So they're going to require this payment up front. That's right. And they're going to put in, more likely, they're going to put in different penalties for things. So if they show up and they're guaranteed a 5-star hotel and they end up in a hotel where there are Venetian blinds and the fluorescent light shining through and bugs, then there are going to be some penalties in play with that. That's right. All right, I think we have time for one last question.
I would have just said that you have to be anal when you're a producer. You need to know, you want to control your universe. And if it is that somebody is just not working with you, you have to be able to walk away from that and say, okay, nice to have, but not critical. I'm going to go elsewhere.
Yeah, and to that point, and then one last question, then we're gonna cut it. And that's this: when you're negotiating with an agent, always have a walk-away point. So negotiate early. Do not wait for the last minute. Agents will turn on a dime. You will think that they're your bestie and you're following you on Instagram and, oh my God, this person is so great. And then if you wait to sign the night before production, instantly they will transform into a demon from hell and absolutely change the deal. The present company of my colleagues excluded, of course. But the point is, you have to have a walk-away point. And I'm serious when I say, if they say, if you agree on a price and they add 1 penny to it, I'd love to be able to. Don't be angry. The worst thing you can do is be angry because they want to get you emotional. The best thing to do is be like, you know what, I get it. I understand. Gosh, it would have been so great if it worked out. But you know what? No, I totally get it. I have somebody else, so don't worry about us. I mean, I have somebody else in the wings. But look, I'll give you a call again if something else comes. See, because now I'm signaling like, dude, it's cool. Right, and they will come back and do the deal. But you have to do that. You cannot get so involved. I've got to have this actor, I've got to have this actor, that it has to work. Okay, so let me cut it there, and then we can do some sort of Q&A as we wrap out if you need to one-on-one. All right, so thank you so much for your time and for bearing with 3 hours of law. And thank you especially to my colleague, Anthony Vieira.